questions since she has the presenter, Justin Myers, at her desk, so it's much easier to communicate that way. So I am just here to introduce Justin. So those of you who attended our webinar back in January, you may recall that there were some really great questions that came out of that conversation, and so we were not able to actually finish the materials that Justin and Paula had created. So this is really just part 2, as if we had planned for more time from back in January. And for those of you that where it's snowing still, it really doesn't feel that different from January 20th on April 6th, which is lovely. So we can just pretend like it's January end of the day. So with all of that aside, Justin Myers is going to be presenting the rest of the PowerPoint. Paula is not going to be with us, but she certainly helped put it together, and we really appreciate your time again, Justin, for helping us out with this. Justin?
Absolutely. Thank you very much, and thanks to the Empire Justice Center for allowing us to come back. But you know, so what I wanted to do today was just very quickly review what a Chapter 7 versus Chapter 13 bankruptcy is, and then we'll get right into the loss mitigation materials that I think is much more of our presentation today. So just as a reminder, Chapter 7 bankruptcy is a short process. It's 3 to 4 months in duration. It's a liquidation, technically, of all non-exempt assets. The debtor is not paying creditors in a Chapter 7. Most homeowners or debtors consider Chapter 7 a full bankruptcy or a traditional bankruptcy. You must qualify financially for a Chapter 7 through something called the means test. The means test is a 6-month look-back period that basically seeks to determine, with certain deductions, whether a family is earning less than the median income for a household of their size in New York State. Those numbers change on a pretty regular basis, so I really can't provide you know, the specifics to you. But figure about a household of 2 is roughly about $55,000 now, and if you need it for reference, household of 4 is about $88,000. So Chapter 7 is a short process, no payments. Many of your clients who are considering trying to retain their home are probably not going to be looking at Chapter 7 as a strategic matter in the first instance. It's possible, but most likely they'd be looking towards a Chapter 13, which is a reorganization of debt. Chapter 13 bankruptcy takes place over a 3 to 5 year period, typically. Basically, all of the debts that someone owes are put in an order of priority, and most important, secured debts like mortgages, cars are all prioritized first. In a Chapter 13, generally, if you can afford some property, whether it be a mortgage or whether it be car payments, you can keep it. It's a common misconception, I think, amongst both chapters of consumer bankruptcy. Property. In a bankruptcy in New York today, practically speaking, very, very few people lose any property that they can afford to keep. Very few people are forced to liquidate property that they otherwise want. There's always the option of a Chapter 13 if in a 7 something is at risk, and in a Chapter 13 it's all about what you can afford. Okay, so we'll move on to the next slide. That's the basics on Chapter 7 and Chapter 13. All right. Paula talked, I think, at length about the automatic stay the last time, and so I'm really not going to spend either. But essentially, 11 USC 362 is the automatic stay provision, and it is the reason people file for bankruptcy. It is the major protection. It is what stops all creditors from continuing collection activity. The important thing to know as you know, housing counselors and folks who are helping debtors is that the automatic stay applies evenly to good creditors and bad creditors alike. So what you need to expect if you have a client in a bankruptcy, regardless of which chapter, is that their statements will change. They will probably not receive a mortgage statement. They will probably not receive a car statement. They will not necessarily have any idea where their payments are being applied on a mortgage on a monthly basis. You may not even see the payments on a statement coming in. And so that can be disruptive to to debtors at the beginning of a bankruptcy, because all of a sudden they feel like they're in the dark. What you need to remind folks is absolutely just keep making your mortgage payments if you were previously. You know that a mortgage payment's due every month. Make sure that happens, and their attorney should be telling them this as well. But the automatic stay will stop immediately upon the filing of the petition with the bankruptcy court. Any foreclosure sales, as long as the gavel hasn't gone down, the bankruptcy applies, and the stay would protect the debtor. The stay is in effect until the end of the case or until the creditor receives an order for relief from the automatic stay, which comes on a notice to at least the bankruptcy counsel and presumably the debtor as well of at least 30 days, so it's not a quick process. And if anything, a bankruptcy filing will delay any immediate injury to the debtor, such as a foreclosure sale, even if for only a short period of time. And sometimes, that's all you need to get an application together, enter loss mitigation, or allow your folks, if loss mitigation has failed previously, to transition out of the home more on a timeline that is a little bit more reasonable for them. Okay, so why don't we switch to the next slide, and we'll get back into the loss mitigation materials. Seems to me that a couple situations occur for housing counselors, and that's you had no idea your client either previously filed a bankruptcy and you're mid-application, or they're in bankruptcy since you've been working with them and they failed to tell you, or they may need a bankruptcy. Well, first we will start with what happens when your client has filed a bankruptcy in the past, and what considerations do you have to think about in those cases. First thing you need to know, what chapter did he or she file? The chapter that they filed in the past is really going to dictate how you can approach your loan modification application, at least in my opinion. A Chapter 7, remember that the discharge occurs right at the very end of the case, or typically at the end of the case. And that process is going to be very short. It's probably not going to affect your loan modification application all that much. In a Chapter 7, you want to know, did they receive a discharge? And the second question is, did the borrower reaffirm the mortgage debt or any other debts that you need to take into account on your budget? Because really mostly what we're talking about here is considerations you're going to be making on your budget or financial worksheet. You do need, on the HAMP form and most every other financial application, the case number, when the date of discharge was, and we'll meet that in the next screen. But for now, you want to know what debt is left. After a Chapter 7 discharge, you're obviously not in need of including any unsecured credit card debt. So if you think that for some reason your client's past debts are coming back, maybe after a denial and a loan modification, or being counted against them as part of their budget, that's certainly something to maybe base an appeal on. HAMP does not require reaffirmations of mortgage debts in order to obtain a loan modification. That's clear in the regulations. I'm probably not telling you anything new. I was looking at version 5 of the regulations, and I believe that appears on in Chapter 2 of the HAMP regulations, section 1.2. So the fact that a debtor has not reaffirmed the debt really shouldn't matter in a HAMP situation. In an in-house situation, I've had banks come back to me, I think once in the past 6 years or so, and claim that they need some sort of debt to be revived in order to do a loan modification. You're put in a tough position. I personally think that it would be improper and may even violate the automatic stay, to which there may be more serious repercussions in bankruptcy court. But when you're talking about in-house modifications and other non-HAMP programs, there just may not be a rule that gets you to the right answer. So effective advocate, if the client is really concerned about reaffirming or the possibility of reaffirming the debt, I think it is something that they seriously need to talk to their bankruptcy counsel about, to determine whether it's the right thing to do. And they need to really make a consideration on the home's value and what they're being asked to reaffirm or revive in some way. What this doesn't include is the subordinate mortgages that FHA loans will require. They're typically, I don't consider that a sort of a reaffirmation. You're asked to sign. It's not really reviving a debt. FHA and HUD, are really just looking to make a balloon payment at the end, and that typically doesn't come back to affect the debtors. They're not paying on it. There's no interest. And so I see very little harm in essentially keeping the status quo, because it's just changing around the lien position. And as far as from a bankruptcy perspective, I have no real concern over that type of new note after a loan modification. Okay, so I've talked a lot about reaffirmation agreements, discharge, data filings. How do you find all that information? If we move to the next slide, I'll show you the PACER system. I believe we had provided the PACER website previously. Oh, we did. Mm-hmm. Ellie's telling me yes. Yeah. Okay. So on the screen here, you'll see at the top of the screen in the center is the case heading along with the case number. You can get to this by simply entering in your client's name and or social security number if you don't know their case number to begin with, and then you'll be able to easily find that. Most of the important information as far as when their discharge occurred, the date that they were filed, will all appear on the right-hand side of the page. Fairly self-explanatory, but you can find the date of filing, the termination date, which is the date that the bankruptcy closed administratively. That will always be after the discharge, if a discharge was issued. The date of discharge appears below that, and as I just mentioned, will almost certainly be different from the date that the bankruptcy was terminated. The rest of the dates there, I don't think come into play for our purposes. If there is no discharge listed on the right-hand side, then you really need to find out what happened. Because in bankruptcy, if they didn't get a discharge, all of their old debts are still in play potentially and would have to be treated accordingly. So if we could just flip to the next slide.
Well, I want to make one comment about PACER because, I think the majority of the people on the phone are housing counselors and they don't necessarily have access to all this information. So if you do want to find some client-level information, your best bet is to work with the legal service provider in your region to see if they can help you get some access to specific client information.
Oh, yes. I think we talked about that last time, but that's a good point to remind folks of. All right. So this is a sample PACER docket report. So once you've pulled up your client's file in PACER, and you do pay for these pages, I think it's 10 cents per page. Don't ask me how many lines the page is, but it shouldn't cost you more than $1 for most Chapter 7 cases. If they received a discharge, you will see the top block here on the screen, which is the no asset report. This is a statement put by the Chapter 7 trustee onto the docket that essentially says, I've reviewed the debtor's paperwork and I've decided that there are no assets of the estate that need to be administered. Once you see a no asset report, if you're in the middle of a Chapter 7, then I think it's fairly safe to say that the case is going administratively quickly and smoothly and would proceed to discharge. Absent some extraordinary circumstances, you can expect a discharge usually within 60 days, give or take, of the reaffirmation. I'm sorry, of the no asset report. Now, what you also want to take a close look at the discharge, the docket on, is whether a reaffirmation agreement was filed. A reaffirmation agreement must be filed in a Chapter 7 bankruptcy for debt to survive. The default rule is if there's no reaffirmation agreement on the docket, then the debt did not survive and was included in the discharge. The reaffirmation agreement essentially creates an exception to the general discharge that the debtor would receive, and it must be on the docket. It should be one line like it is here. The agreement will be filed. You can pull it up. Or actually, no, I'm sorry, you're not able to access the reaffirmation agreement on the General PACER registry. All right. The other items that you may see and want to take note of in a bankruptcy docket are motions for relief from stay. This can tell you maybe how quickly a foreclosure might continue after a Chapter 7 discharge. In this particular case, you can see on the third section down, there was a motion for relief. In a Chapter 7, that's fairly rare. That usually means the bank is moving very quickly and wants to proceed with the foreclosure. They did not feel that they could even wait the 3 to 4 months for the bankruptcy to complete, in which case you really have to hustle on your loan modification application. This happens to be Trustco Bank, the way of loan modifications, but if it was Bank of America, you can bet they're motivated to foreclose. So it definitely gives you an idea of the timeline. The fact that there is a motion for relief from stay in a subsequent order does not affect the discharge. All right. What is indicated here, the reaffirmation agreement happened to be with Capcom. That was probably for a car, but it works and looks the same way if it was a mortgage. Here, we do not see any reaffirmation agreement for the Trustco mortgage, so presumably that was discharged. Again, that would work the same way with regardless of whether it was a credit union or more traditional mortgage lender. Finally, on the bottom, the two bottom sections are orders granting motion for relief. That shows you that the motion from the bank was not able to be deterred by the attorney and they got the relief. And finally, the most important thing in all of this is the discharge. Big deal, little fanfare, one line, but it will give you an idea of what debt is remaining. Okay, we can switch to the next slide now. Okay, so you're working with a debtor or a homeowner, and they have forgot to tell you that they filed bankruptcy in the midst of your loan modification application. It can create some momentary roadblocks, but in the end, it really should not affect the ability of the bank to review your client in a timely manner according to whatever regulations are applicable to them. What you need to find out, and you would not be able to tell from the docket without spending a lot of money and a lot of time, is in a Chapter 7, are they surrendering the home or the property? And if so, why? Surrendering may be a strategic decision made by the attorney and the homeowner, and it does nothing other than indicate an intent to discharge the obligation under the note. In a Chapter 13, you can also surrender property, but if your goal is to go into a Chapter 13 and surrender real property, then your clients are probably not interested in going forward with the loan modification any longer. Just a reminder, there are no reaffirmation agreements in a Chapter 13.
Sorry, go ahead.
There are no reaffirmation agreements in a Chapter 13. That is strictly a Chapter 7 item. Now, HAMP does allow a substitution of documents for a loan modification. You can use Schedules I and J, which in the bankruptcy petition is income and expenses, in place of the normal financial paperwork for HAMP. I've never used it. I've never seen a bank who's willing to use it. And most often, the bankruptcy petition is prepared with a much different goal in mind. Bankruptcy petitions typically try to, for budget purposes, try to show exactly what the homeowner feels that they can pay in or needs to pay in into a Chapter 13 plan in order to get the plan confirmed. That is very different from what you may want to show on a financial application for a loan modification. Do not attempt to substitute bankruptcy schedules for the financial information through the HAMP process. In a Chapter 7, if they were attempting to surrender the property, then their budget shows a vast deficiency every month, because that's how you get a Chapter 7 discharge. You can't show that there's disposable income. But when you're planning for a loan modification, you do need to generally show some amount, usually small, of disposable income. And that is probably not going to be the case in a Chapter 7 bankruptcy petition. Solicitations for HAMP and other loan modification programs may stop once a bankruptcy is filed. This is typically not the case, but often the solicitations look a lot different. Sometimes, as a matter of course, the bank will send you solicitations for HAMP, regardless of whether you were just denied, whether you want it or not, and typically don't mean anything. Particularly if you're mid-process, don't let your homeowners be concerned that all of a sudden they're getting a whole new blank application in the mail. It is often a function of merely the filing of the bankruptcy kickstarts a flag in the bank system, which forces them to generate initial paperwork all over again. But it doesn't necessarily mean that your process that you're in the midst of is somehow thwarted. If your client is in the midst of a Chapter 7 or Chapter 13 bankruptcy and they have completed a trial modification, you must get the loan approved by the bankruptcy, or the loan modification approved by the bankruptcy court before you're able to move forward. Do not rely on the fact that the bankruptcy is closing in a Chapter 7 very soon. Don't let your bankruptcy attorney or the debtor's bankruptcy attorney tell you that, oh, Chapter 7's closing, don't worry about it. My position is, if the trial plan is complete, you need to get it approved by the bankruptcy court. The bank denying it after the bankruptcy is closed for failure to get that approval. Convince the bankruptcy attorney and the homeowner that that needs to happen. In a Chapter 13, that's usually not a problem, because the Chapter 13 process is very long, again, 3 to 5 years, and typically the whole Chapter 13 is designed to in some way pay back the mortgage, and so there's really not that same sort of issue in the Chapter 13. But in a Chapter 7, there's certainly going to be a timing issue that needs to be considered. When you file either a Chapter 7 or a Chapter 13, the review should continue for the loan modification. But my best advice is check with the lender 7 to 10 days after the filing of the bankruptcy, if you're aware of it, that they are still proceeding with their review of the loan application without issue. If there is some sort of issue, or they say, no, we've stopped reviewing it because of the bankruptcy file, you need to get an authorization or some sort of waiver from the bankruptcy court attorney that should allow the bank to continue their review. It's a very simple waiver. We do it all the time. In the chapter, now we all know attorneys are busy people and they rarely get back to your emails to do webinars in a timely manner, and they may certainly not get back to your requests on loan modifications for clients that they just filed in bankruptcy. A lot of bankruptcy attorneys are not familiar with the loan modification process, although that's slowly changing. You need to find out whether their treatment of property in the bankruptcy was based on a strategic decision or whether it was something they failed to have a conversation about with their client, and make sure that everyone's on the same page so you're not wasting your time pursuing an application. Water. Okay. Is there a question? Oh.
No.
Okay. Right. So why don't we switch over real quick to the next slide, which is an explanation or an example of the docket registry on PACER for a Chapter 13 case. In a Chapter 13, again, you'll see the voluntary petition. That is the first item filed in a case. And if you want to spend the $3 or $4 to download that, you can, and it will give you a lot of information on what debts are present in the bankruptcy. It may give you an indication on of the mortgage arrears that your client is facing. But really the more important document, I think, for loan modification purposes is the bottom line here, the Chapter 13 plan. The Chapter 13 plan is the debtor's explanation for what debts are going to be paid in bankruptcy. It's their proposal on how they seek a discharge in bankruptcy. It explains the treatment of the mortgage claim, any secured debts, how much unsecured creditors will get paid, if anything. And it really shows a lot of information about what the overarching goal and plan for the Chapter 13 is. The Chapter 13 plan in the Northern District is a model plan. Every attorney and debtor in the area has essentially the same plan, or at least uses the same form. The most important section for our purposes, I think, comes on Section 1A, which shows the plan payment terms. The plan payment should really be included in your budget on a loan modification. Typically it's at least a few $100s. There are ways through the bankruptcy court's loss mitigation process to include a mortgage payment through the trustee. When that happens, it is usually because they're pursuing loss mitigation in bankruptcy, which we'll talk about a little bit later. Okay. Secured claims, again, just for a review of those folks who maybe didn't remember the last webinar. Secured claims are things like mortgages, car payments, sometimes debts owed on sometimes personal loans can be cross-collateralized. You most often see that with credit union debt. So if there's lots of credit union obligations, you might have to consider that those debts are going to survive the bankruptcy or are going to otherwise have to be included when they might otherwise look like they're a general credit card that might be discharged.
So before we go to the next slide, I think that you must have ESP because a question popped up about 1 second after you asked.
Oh.
So this person asks if you can say what the name of the document is that would show which debt was discharged in a Chapter 7?
Document that is going to show which debts are discharged. The discharge, capital D, in a Chapter 7, or the order of discharge, is going to be a general discharge. So you're never going to see Capital One. You're never going to see Visa, MasterCard listed on a discharge. It is a blanket discharge for essentially every debt that is included in the petition. And I think for loan modification purposes, without getting too complicated, that's all you really need to know. What happens when a debt is usually inadvertently left out of the petition? For loan modification, assume it's discharged. The only exception to that general discharge in a Chapter 7 is anything that was reaffirmed. If there's no reaffirmation agreements on the docket, then you can safely say that no debt has survived. Other than, I suppose I should give, the large example is student loan debt and other tax debts owed to the IRS, State Department of Tax and Finance, any debt owed to a municipality, right down to parking tickets. If you owe the government, bankruptcy. There is a document called the Statement of Intentions in a Chapter 7 petition, and only in a Chapter 7 petition, that stay due with regards to certain secured property. So in a Chapter 7 petition on the Statement of Intentions, we would show whether the mortgage is planned on, at the beginning of the case, being reaffirmed or surrendered, essentially just discharged by the debtor. That is only half of the determination, though. Regardless of what the petition says, it's the absence or the presence of a reaffirmation, or when you're talking about leased property, it'd be called an assumption agreement. In the absence of those two, all of the debt is discharged. If you have, if any of those, that those debts survived the bankruptcy, along with student loans and taxes. Was there a third part to the question?
Well, there's two more parts to the question. So first of all, just the person is asking to define surrender of property.
Okay, so surrendering property in bankruptcy has nothing to do with the title or the deed, as it may sound. Surrendering in bankruptcy is really a term of art that merely refers to the desire to have debt discharged. And that goes back to the documents that are signed when anyone buys a home. You are discharging the note in a Chapter 7, or in a Chapter 13 for that matter, by surrendering property. What you are not doing is immediately jumping to foreclosure, to a foreclosure auction or sale. You are not giving up all of the debtor's rights to maintain and occupy that property. It does nothing to change the deed. And so even if property is, quote, surrendered in a bankruptcy, your client absolutely has the right to remain in that property until a foreclosure auction occurs. And they have the right to continue to try to pay on the mortgage. Happens a lot where even though you surrender it, it's more of a strategic decision to protect the debtor against a failed loan modification in the future, to surrender it so there's no obligation under the note. It protects them against a later deficiency judgment if everything should go very poorly. So I think that's mostly what you need to know about surrender, is that it's only as between the debtor and the borrower. It does nothing to divest the debtor of property.
So then the lender can't go back to the homeowner to collect the money, but they can enforce the mortgage.
They can enforce the mortgage as a lien on the real property.
Right, and then can they, the final part of the question is that then if the lender decides to enforce the mortgage, is the homeowner able then to enter into a HAMP loan mod to keep the home?
Yes. There's nothing that review for someone who has surrendered property in a bankruptcy. If you're hearing that, I think it's very safe to assume that you're either being lied to by the bank or that they're not reviewing it under HAMP. There should be nothing that prevents a bank from reviewing for HAMP on a surrendered piece of property in a bankruptcy, or afterwards for that matter.
And then one more question that's here. I think you kind of answered this already, but I'll reiterate just to be sure. But this person is asking if the listing of what's discharged would be on the petition and the trustee's closing statement.
No, it's not going to be on the trustee's closing statement. I guess it's not a straightforward answer. The petition, in a perfect world, in a perfect bankruptcy, should list all of the debts and obligations of the filer. If it's not listed, it depends what kind of debt you're talking about, but assume for the purposes of our conversation that all of the debts are listed in a bankruptcy. Yes, you can assume that those are the debts that are discharged in the absence of a reaffirmation agreement or a assumption agreement in the case of a lease. It's important to maybe realize that a bankruptcy discharge only applies to debts that existed at the time of the bankruptcy filing. Any debt that arises after a bankruptcy, the date of filing of a bankruptcy petition, is outside the scope of the bankruptcy and is still enforceable. I think where this becomes particularly problematic is with, you don't often find this with credit cards because credit is not something that usually comes back right away to a debtor in bankruptcy, not immediately, but medical bills can pop up at any time or they're billed late, and so sometimes the delay can be confusing there. But if there's a bankruptcy discharge, you can assume that anything beforehand is discharged in the absence of a reaffirmation.
Question about, does that include escrow advances for the properties?
Yes. Yep.
Okay.
Yep. Pure and simple. Yes. And remember, taxes, real property taxes, school taxes, or anything that would be put on the tax bill is not a personal obligation of the debtor. It is an obligation or lien as to the land. It will always act as a lien on the property, but it is not a personal obligation of the debtor. If you do not pay your real property taxes or your school taxes or your water bill, the only thing that the municipality can do is foreclose on you. They can't garnish a debtor's wages for not paying a water bill.
Oh, that's good to know. Okay, if you're ready, I think we can move on to the next slide.
I think so, yes.
And just a time check, we are at about 20 minutes.
I see that. Okay, so your client has already filed bankruptcy and they didn't tell you. I think the most important first call you can make, oh, I'm sorry, I'm on the wrong slide here. Yep, I am. All right, so signs your client should consult a bankruptcy attorney. Their settlement conference has closed or a foreclosure sale is imminent. I do unfortunately see a lot of folks coming in on the eve of a foreclosure sale because, you know, whoever they were working with, whether it be a housing counselor, foreclosure attorney, just was a little bit too optimistic and, you know, fought until the bitter end, and it needed, when it didn't work, they had to file bankruptcy in very quick order, which is always a little bit dangerous because in a rush, something will get missed. So whenever a settlement conference closes and you just must keep the property, get them to a bankruptcy attorney. Multiple mortgages without equity. So Ellie and I were just talking about a situation like this before we went live today, where if there are multiple mortgages on a property and the second mortgage has no equity that attaches to it, the first mortgage effectively puts the property underwater. Then bankruptcy, Chapter 13 in particular, is a really powerful tool when you're trying to help someone save their home. We can strip second mortgage liens in a bankruptcy that have no equity as to the property. It's called a pond motion or a Roberts motion in bankruptcy court, but essentially it can just discharge a second mortgage debt for the mere fact that it is not really secured. It is an unsecured debt because there's no equity in the real property. Wage garnishments. When you're trying to save a home, the last thing you need is a creditor taking 10% of your wages every pay period. Most folks cannot survive a wage garnishment and keep their rest of their budget on track. So that may be a very good time to send them to a bankruptcy. If there are judgment liens, this comes into play all the time when we're trying to do loan modifications with folks in state court. You get a great answer, you get a great approval on a loan that you've struggled for months over, and during the course of the trial plan, the bank comes and tells you that we have some title issues that need to be cleared up. Well, unless your client can then find money to clear up judgment liens that are still valid, the only way to remove those from the title is by filing a bankruptcy in the absence of payment. If when you're going through your client's budget and you see on their credit report that they have unsecured debts, meaning credit cards, medical bills, personal loans, greater than $10,000, and it is affecting their ability to pay the most important things in their life, their mortgage, their cars, food, utilities, that may be an indication that a bankruptcy would be very useful to them. And the most obvious is if credit cards are being prioritized over housing expenses, then bankruptcy may be the... Okay. I did cover last time very quickly the loss mitigation programs that are present in the various districts in New York. The programs are relatively similar and have a few technical differences between the districts. And the most important thing, I think, to understand is, particularly upstate, the Northern District's loan modification program is very receptive not only to working with housing counselors in a creative way on particularly difficult cases, but it's also incredibly useful to negotiate through a particularly difficult application process. So if you have folks that are self-employed with 10 different side jobs and sources of income, and they rent a room in their house 4 days a week to a part-time business and whatever other circumstances you can possibly imagine, rather than a dozen calls to the relationship manager and or letters of explanation to the underwriter, and with the attorneys on both sides to sort things out in a way that just hours of phone calls cannot. The judge has great power to order us to stay in the courtroom until something is decided. Generally speaking, it's a 90-day process, or at least it's designed to be a 90-day process. In practice, it ends up being a little bit longer. But almost always, I'm getting a full review of the financial information somewhere between 60 and 90 days out. The process is available in either a Chapter 7 or a Chapter 13. although overwhelmingly the loss mitigation applications are being submitted in a Chapter 13. Chapter debtors, attorneys to get paid, and typically the strategic decision is to go into a 13.
And if there's, just very quickly, if there's two people on the first mortgage, do they both have to file Chapter 13?
No.
To get the second stripped?
Then yes, in a mortgage, yes. If both are obligated under the debt on the second mortgage, then you would want them both filed in the 13.
It's on the second mortgage, but if they're both on the first mortgage, but not on the second?
That would be an unusual situation.
Okay.
But I would say that no, in that case you would only need one of the homeowner obligated under the note. Either way, the person who's filing bankruptcy must be obligated under the note.
Okay. I think just very quickly, if you kind of did a brief explanation of where is the Northern District?
Oh,
just because you have housing counselors who aren't familiar.
The Northern District extends from Ulster County on the southern end all the way up to Canada, so it's at Essex and Washington, Warren County, and out west to Syracuse. The Western District is anything essentially west of Syracuse, and then downstate below Ulster and Columbia County is typically the Southern District, and the Eastern District is on Long Island. Suffolk County. There are a couple of unusual cases. Ulster County can file in either the Southern District or the Northern District, as well as, I believe, parts of Dutchess County. The venue is almost always certainly going to be the option of the debtor and or their attorney. Okay. All right. So bankruptcy loss mitigation process is a relatively short process. In almost every case, I'm getting decisions, like I said, before 90 days. There is a strict scheduling order that more or less must be adhered to. There is continuous judicial supervision. Our judge holds loss mitigation hearing dates about every 2 weeks, and so there is very rarely long periods of time before you find out that something else in the application is missing. You don't end up on that hamster wheel of missing documents, letters, and constant updating of paperwork that you sometimes see outside of a judicial process. How housing counselors can engage in this process, we talked about briefly. Start developing relationships with at least one or two local bankruptcy attorneys in your area who seem relatively knowledgeable about loss mitigation. I'm sure loss mitigation is not one of those things that you can often fake knowledge of, and housing counselors I find are particularly good at one who's not.
So I'm going to, since you took the little break to take a drink, I'm going to interrupt because somebody asked a question. If there's some extenuating circumstance for a second mortgager who can't, for whatever reason, sign and file a bankruptcy, would one of the people be able to file a Chapter 13 and then prove that they can pay the whole mortgage?
Well, I guess
within the...
It's hard to without a little bit more detail, but let me, I think, answer the question. Only need one obligor under the note to file a bankruptcy, but if we're and to have the automatic stay in effect. So I guess it depends on the goal. If the goal of the bankruptcy is to stop a foreclosure sale, then you really only need one. Now, in terms of legal efficiency, and if both, say, spouses are obligated under the note, then you want them to file bankruptcy at the same time. If it's a situation, I suppose maybe the question is getting at if someone is out of the country or in a hospital, then you really need to talk specifically to the bankruptcy attorney about that and what they can come up with creatively to get someone filed. Was there a second part of that question? I'm sorry.
No, that was pretty much it. That was, about trying to figure out how to incorporate other income if they aren't.
Oh, you can always incorporate other income because it's a household income. So for loan modification purposes, you're not going to, you can always use contribution letters. And if you're just talking about, if this is a question from a bankruptcy practitioner, then this is, you certainly need to include all of the household income, particularly if the folks are married. If they are not married under the law, then there's a little bit of gray area. You probably want to use it as a contribution on, not only under the means test, but on Schedules I, which is their income statement. But you don't necessarily have to have a dollar-for-dollar match based on their income. Now, you may need it, but you don't have to. All right. So how can housing counselors get, I'm sorry, we'll talk briefly about the Eastern and Southern districts again. Like I said, the processes are relatively the same. There are some differences in technical differences for bankruptcy practitioners to know about what happens to debtors while in bankruptcy. In the Eastern and Southern districts, as well as the Northern District, motions for relief, or MFR, are stayed during the pendency of the loss mitigation process. So until loss mitigation is over, applications for relief from the state cannot go forward. In the Eastern and Southern District, confirmation, which is important for monetary purposes and how creditors are getting paid in bankruptcy, is adjourned until loss mitigation is concluded. In the Northern District, that's not the case. And now in the Northern District, debtors are required to make mortgage payments of some sort, either into the trustee or directly to the creditor during the pendency of a loss mitigation. I think that's really that's important for the differences in the programs. I think what is particularly important to, our group today is how you can get involved. Find local bankruptcy attorneys in your area who seem to know a little bit about loss mitigation and see if they are willing to work with you. We, on several occasions, have brought housing counselors in to handle a particularly difficult loan modification application in bankruptcy court, because it is much more financially feasible for a housing counselor who's typically working for free for the homeowner to go through the process and spend the time versus the attorneys who almost always need to be paid for it. And for better or for worse, our bills can reach into the thousands while going through a loss mit process, and sometimes that just pushes the budget for a homeowner. I do see a quick question that is Westchester part of the Eastern and Southern District. No, my understanding is that it's only part of the Southern District. Long Island is in the Eastern District. Most of the counties of New York City are in the Southern District.
And the Hudson Valley is in the Southern District.
Hudson Valley is almost exclusively going to be in the Southern District. The only depends what you call upstate, right? But Ulster County is either in the Northern District or in the Southern District. You have the option.
Okay.
And Brooklyn and anything on the eastern part of the 5 boroughs is in the Eastern District as well. There is maps on the websites that will exactly what counties are covered by which district. But the boundary lines, I'll admit that I don't know every one of them. helpful just for housing counselors to get a sense of idea of, one, what they may be walking into on a case, and two, may spark some conversations and ideas about how to really get involved for your clients in their bankruptcy. The hearings are on Monday mornings. They typically go from about 9:15 to, whenever the calendar can get done, about 12. They tend to be every other Monday in the Northern District. You can go on the Northern District Court's website with the link that we provided to see when the next calendar call is. And I see very accurately I'm being corrected on what is in the Eastern District.
So yeah, somebody has posted that the Eastern District is Kings, Nassau, Queens, Rockland, and Suffolk.
There is no mediation in the Western District of New York at this time. It's my understanding through the grapevine and of somewhat of a political nature, it is not something that is planned to be there anytime soon. So the Western District of New York folks, unfortunately, are a little bit left out of this game. However, if you are representing homeowners in the Western District, I think a lot of what we talked about today still applies. Although you can't use the process through the bankruptcy court, if you know what the treatment of your mortgage that you're dealing with is, what treatment it's receiving in bankruptcy, then you're going to be more able to help your loss mitigation client outside.
Okay. So remind us again on these two questions. If only one borrower files, does it mean the other borrower has a bankruptcy on their record? And if a borrower states the mortgage was not included in the Chapter 7 because the loan was current, is that true?
No. In fact, I'm sorry, the second part of that question I'll address first, because it's a very common question and something that most debtors will get wrong about 100% of the time, okay? It's the best way to explain it is that regardless of whether it was quote unquote included in the Chapter 7, is to assume that yes, it was properly listed. Okay, borrowers get this confused. The debts should have been listed in their Chapter 7. If it wasn't, that's a really big issue that just by the whether or not they were included in the absence of a reaffirmation agreement, they're discharged. Okay. The first part of that question, if only one borrower files, does it mean the other borrower has a bankruptcy on their record? If you're talking about their credit report, most of the time the credit reporting bureaus will show that a loan account is in bankruptcy. I'd like to give the benefit of the doubt to any loan officers who are looking at credit reports, and if they're worth their weight in salt, they would know that if that's the only account that shows as in bankruptcy, that the co-borrower didn't file. But it doesn't mean a bankruptcy is on the record of the non-filing co-borrower.
So at this time, there's no further questions, so I'm going to hand it over to you, Becky.
Okay, so I think that maybe I missed it. Did we address the fact that there's no mediation in Western District?
Yes.
Okay, so just as a reminder, this is not a CLE, so you will not be getting CLE credits for today's session. It was really focused to assist the housing counselors in our state to make sure that you are comfortable, or at least as much as you can be without being a practicing attorney on this, with bankruptcy. And so if you would like a certificate of attendance, just make sure that you send your email off to Michelle, and we can make sure that we get one for you. Other than that, that's all we have. So Justin, again, thank you for the first part in January and for the follow-up for today. And no worries about getting back to us. You did just fine, and we appreciate that this is a very busy time for you, and so we really appreciate you spending the time with us today. So that's it. Have a good day, everybody.
Very much for having me. I appreciate it.
All right. Thanks, everybody.
Thanks.